Mark says, my nonprofit is negotiating a contract for services, and the service provider is asking for indemnification against all claims and losses. What exactly does it mean to indemnify? And is this an appropriate thing for a nonprofit to agree to? And would it be better if we insist that the indemnification is mutual? Okay, Mike, I'll start on this one because I get this question a lot. The devil is really in the details when it comes to indemnification, but in general, what it means, if you're asked to indemnify, basically you're asked to reimburse the other party for costs that they incur for some reason related to the contract. So it's kind of a risk management clause where it's shifting the risk to one side or the other with regard to very specific circumstances, or sometimes, and I don't like this, but sometimes it's very general and very broad. And I don't know in this case, how broad is the indemnification? It sounds like it may be very broad. Indemnification against all claims and losses. There might be some more language there that has not been shared. But it can be an okay and appropriate thing depending on the circumstances, but is never something to agree to lightly and really requires a lot of thought, because when you agree to this, you're just exponentially increasing the risk of whatever the arrangement or transaction or activity is. Where would it be appropriate? Okay, if the organization has some intellectual property, for example, that it's licensing, and it's claiming to have the right to give that license and allow somebody to use that intellectual property, a copyright, a trademark, something like that. If some third party comes out of nowhere and says, you're breaching my rights to this, you weren't allowed to license that, the licensee, the person on the other side of that contract, had nothing to do with that situation. So if they want and need that protection within limits, that could be something that's appropriate. That kind of makes sense. But when you get into service providers, like if it's an event and they're asking to be indemnified for, everything under the sun that has anything to do with the event, that's where I would push back and, try a few different things. You might, in some circumstances, want to strike it entirely, not agree to any form of indemnification. You might want to explore putting stricter limits on it, meaning not having the obligation to indemnify for anything that is an act or omission of that other party. Important point, I always want to make sure that it says third-party claims, liabilities, etc. Because if it's not specifically limited to third parties, I worry that it then gets used somewhere down the road as a weapon against the counterparty. If you need to sue, but you're also required to indemnify, that happens sometimes. Where you're paying for your own lawsuit to assert your rights. So that's something I watch for. You may also want to have a higher standard. So, okay, we'll agree to indemnification, but only if there was negligence or gross negligence or willful misconduct or something on our part. So these are ways that you can take a big, broad indemnification obligation, really pare it down to something that makes more sense. But in the right circumstances, it is something a nonprofit can agree to. It often has no choice with certain parties that it's contracting with, but it's really an area where you want to look very closely at it. That's my initial thoughts. I may think of some more because I end up looking at a lot of indemnification clauses. What are your thoughts?
All really good points. And contracts, we've talked over, I think you and I have contract conversations on a consistent basis. And that's my point here. You need to work with your legal team, your internal teams when it comes to contracts. And indemnification clauses of some kind are not unusual. The key I have here is the word all. I just don't think it could be even to the point where, and I'm not an attorney on this, where if I saw all in there, I would can we sign this contract? I think, so Ben, I like your comment because, when we see things that get in trouble, a lot of contracts are not for 2 weeks. They could go on for years, and there's things that could happen in the future. You don't even look around us that we don't even know about.
Yeah.
Like an inflation problem that we weren't even thinking at the time we signed the contract.
It's a hard thing sometimes if you're just leading a nonprofit organization or working for one to put yourself in that position of envisioning, well, what could happen?
Exactly.
And that's where professionals can provide a help there. And 2 points you reminded me. Number one, if you're going to agree to indemnification, take a look at your insurance policy, your comprehensive general liability insurance. Talk to your broker. Find out whether there are provisions that might limit your ability to agree to indemnification or that may have an impact on this language you're agreeing to. Because if something arises, you're going to need to draw from that insurance. Usually, in these worst case scenarios, there's usually not enough funding on hand to cover it. So the insurance is super important. So make sure that you can do that if you have to agree to some form of indemnification. And the last point, I'm not sure if I addressed the thing about mutual indemnification. I'd say one mistake people often make is just kind of too easily agreeing to it as long as you make it mutual. So I indemnify you for your conduct, you indemnify me for my conduct. That is an improvement in some cases, but you really got to think through. Sometimes each party is not incurring similar risk. Picture the scenario. It's like much more likely one party's going to get sued than the other. So kind of making it mutual doesn't really alleviate that balance. So not every approach and solution is right for every circumstance. So it's an area where organizations need to be careful, and they most need professional advice in these situations.
Yeah, and Ben, I'd like to comment back on the insurance. That's a great example of you reach out to your legal team and they're going to have not only say yes or no, they're going to have maybe possible solutions. The insurance might have great, one, if they're aware ahead of time, they're going to be with you. Number two, oftentimes when we've reached out to insurance or other professionals, they have solutions. They say, hey, thank you for letting us know. Here's some wording that could work that won't impair you from an insurance perspective. Just like we do that with banks all the time when we're looking at loans or, looking at real estate, talking with them. And we have attorneys sitting behind all those. And you're actually paying for that service and the fees you're paying. Right. And I found some amazing resources that have come out of having regular communications with my insurance providers, with all different types of clients. And you're getting a yes, no sometimes, but you're also getting solutions.
Yeah, and it's in their interest, because if the insurance company is going to be on the hook, they want to help you strengthen that language.
Exactly.
So
and if we use their wording,
in that case,
it takes away one more oh, you did something wrong.
Yeah, great tip, yeah.